Okay, so I'm going to kick off the presentation on mediation. And if you have any questions, you can feel free to ask me in the chat box. If I can see to it, I'll get it. Otherwise, you also can ask me on email if you have anything to add. Or at the end, when we have Q&A, you can raise your hand. Alternatively, I'll deal with the question that might have come up earlier in the Q&A, right? Okay, so this is our first ADR Masterclass for the year, and it's on mediation, and it's part of the South African University Mediation Enthusiasts Group. Okay, introduction to mediation. So we're going to touch on the definition and purpose of mediation. We're going to look at the benefits of mediation versus other dispute resolution methods, like litigation and arbitration. And we're going to look at real world applications of mediation. So mediation is a structured, voluntary, and confidential process where a neutral third party, the mediator, facilitates communication between disputing parties to help them reach a mutually acceptable resolution. Unlike litigation, which is adversarial and decided by a judge, or arbitration, where an arbitrator makes a binding decision, mediation empowers parties to negotiate their own solutions. The definition and purpose of mediation. So mediation is a form of alternative dispute resolution, or ADR, that emphasizes collaboration, communication, and problem solving rather than confrontation. It is firstly voluntary, both parties choose to participate. It's neutral. The mediator does not take sides or impose a decision. It's confidential. Discussions remain private, encouraging open dialogue. It's self-directed. The parties themselves determine the outcome. And the goal of mediation is to create win-win outcomes where all parties feel heard and respected while reaching a fair and sustainable resolution. So what are the benefits of mediation versus other dispute resolution methods? We're going to look at the cost factor, the time factor, control factor, confidentiality factor, and relationships factor, and flexibility factor. When you look at mediation, the cost is low. Okay. We look at litigation, the cost is obviously high because you have legal fees and other costs. And if you look at the cost of arbitration, it's sort of middle of the road, right? Looking at the time factor, so with mediation, it can be very quick, from a couple of hours to weeks or days. Litigation, as you know, it's probably the longest, can take months and years. And with arbitration, the time factor is, again, probably not the road, right? Control factor, so with mediation, like I just said, the party decide outcome. With litigation, of course, the judge makes a ruling. With arbitration, the arbitrator decides. With confidentiality, with mediation, it's private. With litigation, it's on public record. And with arbitration, it's usually private. In terms of the relationships, mediation preserves relationships. Litigation is often adversarial, and parties can come out on the outside having one party having won, but the actual relationship is worse off, right? Arbitration can be adversarial, right? In terms of flexibility, mediation is a highly flexible process. Litigation, as you know, rigid court procedures, timelines, etc. And with arbitration, there is some flexibility. That's just a sort of a side-by-side comparison based on key factors, right? And of course, you have to walk a client through these in order for them to decide on the best mechanism, right? So the key advantages of mediation, as you might have picked up, is that it's less expensive and faster than litigation. It encourages cooperation and preserves relationships. Custom solutions are tailored to the parties' needs. It's informal and flexible, allowing for creative problem solving, greater compliance, since agreements are mutually crafted. Real world applications of mediation. So mediation is used in various fields, making it a crucial skill across professions. So of course, the prime example is the legal field. So in legal and business disputes, mediation is used where there are contract disagreements, employment conflicts, as you know, with the C.C.M.E., and commercial and consumer issues, right? Another place where it's used is workplace and organizational conflicts. So again, the C.C.M.E., disputes between employees of departments, and of course, internal procedures as well, right? We have that as one of the mechanisms. Labor and management negotiations can inform mediation, harassment and discrimination claims. Family and community mediation, very popular and ideal field for mediation to be used. So in divorce and custody agreements, landlord-tenant conflicts, neighbor disputes, and also be used in education and schools. So resolving student conflicts and bullying, special education mediation, and of course, faculty and administration disagreements among staff. International and political mediation, so it's not just local and between private people, can be used in diplomatic negotiations, peace treaties, and conflict resolution. International trade disputes, healthcare mediation, that's also another popular area with the South African Medical Legal Association. They mediate patient-provider disputes, end-of-life care discussions, like those that have terminal illnesses. It's often a contentious issue, and insurance claim resolution. Right? So those are some of the areas of life and business and society that mediation can do. Of course, that list is not exhaustive. The core principles of mediation. Firstly, neutrality and impartiality, confidentiality, voluntary participation, and self-determination of the parties, or sometimes referred to as self-autonomy or party autonomy. So mediation is guided by a foundational principle that ensure fairness, trust, and effectiveness in the process. These principles distinguish mediation from other dispute resolution methods and help create a constructive environment for resolution. So firstly, neutrality and impartiality. A mediator must remain neutral and impartial. Sometimes they refer to that as being omnipartial, right? Or omnipartiality, meaning they do not take sides, favor one party, or impose their opinions on the dispute. Neutrality refers to the mediator not having a personal stake in the outcome and treating all parties equally. Impartiality, the mediator does not show bias or favoritism towards any party. Why does neutrality and impartiality matter? It builds trust between the mediator and the parties, right? To ensure that all perspectives are heard and respected. It helps prevent the perception of unfairness, which could lead to a breakdown in negotiations. Challenges to neutrality and how to overcome them. Implicit bias. So mediators must be aware of their own biases and actively work to minimize them. Where we all come to life, the situations with biases, and it's important to be at least aware of them and in mediation not allow those biases to play on the mediation process, right? Power imbalances. So if one party has more influence, for example, an employer versus an employee, the mediator must ensure fair participation. Emotional involvement. Mediators must avoid getting personally invested in the outcome. Confidentiality. The mediation is a private process, and all discussions must remain confidential unless parties agree otherwise. Mediators cannot disclose information shared during mediation without consent. In many legal systems, mediation agreements include confidentiality clauses. Some exceptions exist, such as cases involving debts or harm or illegal activities, in which case it's okay to break confidentiality. Why does confidentiality matter? It encourages the open and honest communication without fear of repercussions, allows parties to explore creative solutions without concern for public exposure, and it builds trust in the mediation process. So an example of this is in workplace disputes, confidentiality ensures that sensitive issues such as harassment allegations are addressed discreetly, protecting reputations and professional relationships. The third principle is voluntary participation. So mediation is not forced. All parties must choose to participate freely. Parties have the right to leave at any time if they feel mediation is not working. There is no legally binding decision unless the parties reach a mutual agreement. Unlike litigation or arbitration, where a judge or arbitrator imposes a decision, mediation relies on cooperation and willingness. Why does it matter? It ensure that parties are engaged in the process, leading to more meaningful agreements. It creates a less adversarial environment compared to courtroom battles. It encourages personal accountability and commitment to solutions. The challenges, right? Sometimes one party will be affected into mediation, for example, by an employer or by the legal system. The mediator must ensure that participation is truly voluntary. The fourth principle is the self-determination of the party, so party autonomy. The mediation empowers parties to take control over their own outcomes rather than having a third party dictate the resolution. Parties identify their own interests and decide on acceptable solutions. The mediator facilitates discussion, but does not impose solutions. Encourages creative and customized agreements rather than rigid legal decisions. Why does self-determination matter? Solutions reached through self-determination are more likely to be followed because parties feel ownership over them. It encourages collaboration rather than confrontation, and it fosters long-term problem-solving skills and reduces future disputes. So hopefully the parties will learn from what's been done, and they won't come back to you. It will inevitably improve their own problem-solving skills and ensure that they frequent your office less often. So an example is that in a family dispute over child custody, the parents, rather than the judge, can craft an arrangement that best meets their child's needs while also addressing their own concerns. So the mediation process, right? So there are 5 stages. The process can be more or less, right? Firstly, is the pre-mediation stage. So this is obviously preparation, setting the ground rules and initial briefings for the pre-mediation meeting. Okay, and then once the mediation starts, you have opening statements where the role of the mediator is set out and the parties give their perspectives on the conflict. Then you get to what could be the longest part of the mediation process, which is exploration and issue identification. And of course, this requires active listening skills and clarifying interests in order to get to the heart of the matter. Negotiation and problem solving, right? So this is coming down the hill now, where you generate options, right? And you find common ground. Agreement and closure is about reaching consensus and drafting settlement agreements. So the pre-mediation stage, you're going to have firstly preparation by the mediator. Before mediation begins, the mediator gathers background information, understands the dispute of the parties involved and key concerns, schedules the session, determines a convenient time and neutral location or virtual setting, and of course the parties can be involved in this process as well. Reviews any prior agreements or legal frameworks that may impact the discussion, right? Setting the ground rules. So the mediator establishes guidelines to ensure a respectful and productive discussion. Common ground rules include one person speaks at a time, no interruptions, respectful communication, no personal attacks, confidentiality agreements, right? Discussions remain private, willingness to listen, and means everyone's perspective is heard. Initial briefings with the parties. So the mediator may meet separately with each party in caucuses, or as we know, in breakout rooms, to understand concerns and expectations. Parties may be asked to submit a brief summary of the dispute and desired outcomes. This stage sets the foundation for constructive discussions by ensuring all participants are prepared and understand the process. Opening statements. The mediator's opening statement. So the mediator officially starts the session by introducing themselves and explaining their neutral role, outlining the mediation process and expected outcomes, reaffirming ground rules and confidentiality, and encouraging a collaborative meeting. The party opening statements, each party presents their perspective on the dispute. This is firstly an opportunity to express concerns in their own words, not a debate, so other parties listen without interruption. a chance to outline what they hope to achieve by mediation. Here, an example is in a workplace conflict, an employee might express concerns about unfair treatment, while a manager may highlight operational challenges. Both perspectives help frame the discussion. The third stage, exploration and issue identification, right? So identifying key issues, the mediator helps clarify the root causes of the dispute. Parties may move beyond surface level complaints to explore underlying interests. For example, an employee may want fairness, not just a promotion. So the appeal for promotion may just be because they want to be treated fairly. Active listening techniques, right? So mediators use active listening to ensure understanding, right? So things like paraphrasing, right? Where you say, so what I'm hearing is that you feel overlooked for promotion. Okay? So after they have spoken, then you put it in your own words, which is a call for clarification. You use open-ended questions. Can you explain why this issue is important to you? Validating emotions. It sounds like this has been a frustrating experience. Reframing issues. Okay. So this is another technique, right? Where you're shifting from positions, which arguably is what opened the conflict, right? So there were rigid demands to interests which are underlying, right? So for example, instead of I want a raise, a party might express, I want recognition for my contribution. By clarifying issues and interests, mediation moves toward problem solving rather than healing. Okay, number 4, negotiation and problem solving. So firstly, brainstorming solutions. The mediator facilitates creative problem solving, encouraging parties to suggest possible solutions. All ideas are considered before narrowing down action. Finding common ground. Parties identify areas of agreement, even if they are tiny. Okay? The focus shifts to win-win solutions rather than compromise alone, where one person loses out. Reality testing, right? So the mediator asks, would this solution be comfortable for both of you? Right? And of course, this process can go back and forth, right? Doesn't go through the stages in cut and dry fashion. Helps parties assess the feasibility and fairness of proposed agreements. So for example, in a landlord-tenant dispute over late rent, possible solutions could include a modified payment schedule, a temporary rent reduction in exchange for property maintenance work, a structured exit plan if moving out is the best option. In the 4th stage, agreement and closure. Okay, finalizing the agreement. So once a resolution is reached, the mediator helps summarize the key terms. Any remaining concerns are addressed, and the agreement is clear, specific, and realistic. Drafting a little settlement. So the final agreement is documented in writing. It should outline specific responsibilities, deadlines, and next steps. The mediator ensures both parties fully understand terms. Follow-up and next steps. So in some cases, follow-up meetings ensure compliance. If no agreement is reached, mediation may still include communication for future discussions. So the mediation process moves from understanding the problem to finding solutions in a structured, respectful way. By following these steps, mediators guide disputing parties towards agreements that meet their needs while preserving the relationship. Essential skills for effective mediation, right? So You would have heard some of it already. So firstly, active listening and empathy. Secondly, communication and questioning techniques. Thirdly, managing emotions and de-escalation strategies. And lastly, reframing and problem solving approaches. Successful mediation relies on a set of core skills that help facilitators navigate conflicts, promote dialogue, and guide partners towards resolution. These skills ensure that mediation remains constructive, respectful, and solution focused. So, firstly, active listening and empathy. So, what is active listening? Active listening goes beyond simply hearing words. It involves fully engaging with what the speaker is saying and demonstrating that their message is understood. So key techniques, again, include paraphrasing. So you restate what the party has said to confirm understanding. For example, so you say you feel excluded from decisions and work. Another way to demonstrate active listening is through summarizing, right? So you condense key points to clarify issues. For example, it sounds like your main concerns are fairness and better communication. Clarify, asking follow-up questions to gain deeper insight. For example, can you explain more about what you mean by lack of respect? Nonverbal engagement, so maintaining eye contact, nodding, and using an open posture to show attentiveness, to show that you're listening. So empathy, right? Empathy allows mediators to connect with emotions behind the conflict while remaining neutral. So ways to show empathy. Firstly, you're going to acknowledge emotions without taking sides, right? For example, I can see that this situation has been frustrating for you. Use a calm and reassuring tone to create a safe environment for dialogue. How parties recognize each other's emotions to build mutual understanding. For example, in a workplace dispute, an employee may feel undervalued. Instead of dismissing their feelings, the mediator might say, it sounds like you're looking for more recognition in your work. Let's explore ways that we can. Communication and questioning techniques. So effective communication, mediators must be clear, neutral, and encouraging in their communication. Key strategies to do this is to use neutral language. So you avoid blame or any loaded terminology. Encourage open dialogue by fostering a safe space for both parties. You control the pace of the conversation to keep discussion productive. Okay. Listening techniques, right? The mediators use different types of questions to guide discussions and uncover deeper issues. For example, we had landlord-tenant dispute over noise complaints. Instead of asking, are you willing to stop playing loud music at night, which is a yes/no question, the mediator could ask, what changes could you make to reduce noise while still enjoying your space? Okay, this invites creative solutions. So on the left or right, depending on how you see in the screen, there's a table about the type of questions, the purpose, and an example, right? So with an open-ended question, you ask an open-ended question because you want to encourage deeper discussion, right? For example, can you describe how this issue has affected you? A clarifying question, you ask this question to ensure clear understanding. So an example would be when you say fair treatment, what does that look like to you? A reflective question helps parties consider their stance. For example, we'll ask, how do you think the other party views this issue? The reality testing question assesses feasibility of solution. For example, if you were to implement this solution, what challenges might arise? Okay. Another core skill is managing emotions and de-escalation strategies. Understanding emotional triggers. So people in conflict often react emotionally due to frustration, fear, or a sense of injustice. Recognizing emotional triggers helps mediators intervene before situations escalate. So what are some de-escalation strategies, right? Firstly, you as a mediator, you have to stay calm and composed. A mediator's calm demeanor helps reduce tension. Acknowledge emotions. So we say, I can see this is upsetting for you. Let's take a moment to understand why. Encourage a pause if emotions rise. Taking a short break can reset the conversation. Use neutral rephrasing instead of you're being unreasonable. Say, let's find a solution that works for both of you. Conflict reframing. So when emotions run high, mediators reframe negative statements into constructive dialogue, right? An example, if one of the parties says, they never listen to me, I'm tired of being ignored, the mediator might reframe that to say, it sounds like you feel your voice isn't being heard. What would you feel? What would help you feel more included in decisions? By managing emotions and de-escalating conflicts, mediators create a space where real progress can be made. Okay, so is not a mediation not a silver bullet, right? So there are challenges within the process. Maybe you're dealing with real people. So there are definitely challenges, but there are ways to overcome them, right? So some common challenges in mediation are firstly power imbalances and difficult personalities, overcoming deadlocks and stalemates, cultural sensitivity, and bias awareness. So firstly, power imbalances and difficult personalities, recognizing power imbalances. And power imbalances occur when one party has significantly more authority, confidence, or knowledge from the other. Okay, this can happen in workplace disputes, for example, employer versus employee, legal or business conflicts, for example, a large corporation versus individual consumer, in personal relationships, for example, abusive dynamics in family mediation. Challenges created by power imbalances. So one party may dominate the conversation while the other feels silent. A weaker party may agree to favorable terms just to end the dispute. The more powerful party may use intimidation tactics, for example, threats, legal jargon, or emotional pressure. Strategies to address power imbalances. So the pre-mediation sessions are key, right? Where you meet separately with parties to assess any imbalances upfront. Equal speaking time, so you set ground rules, ensuring both parties can express themselves. Reframing power dynamics, highlight mutual interests to shift the focus from control to collaboration. Third party advocates, if needed, bring in support persons, for example, legal representatives or workplace advocates. So the big one is, of course, handling difficult personalities, right? Some participants may be aggressive, passive aggressive, manipulative, or uncooperative. For example, in a workplace dispute, if a manager dominates a conversation while an employee is silent, the mediator might say, let's ensure both perspectives are fully heard before making any decisions. I'd like to hear from each of you. Okay, so there's another table here that gives you the difficult personality type, the challenges they pose, and of course, possible strategies that you as a mediator could do. So, do you have an aggressive or dominating personality? The challenge is going to be they're going to interrupt, intimidate, insist on having their own way. You as a mediator can overcome this by setting clear ground rules, using neutral but firm tone, and enforce equal speaking time. A passive or withdrawing personality, the challenges they can pose is they avoid discussion or refuse to engage, encourage participation, then ask open questions, and use private purposes if needed. Okay, and the manipulative personality, The challenge there is that they will twist facts, play the victim, use guilt, right? You as a mediator can stay neutral, fact check statements, clarify and reframe the proofs. The emotional or the explosive personality type, um, the challenge they can pose is that they can react emotionally, when you shout, when you cry. So as a mediator, you can acknowledge the emotions, suggest a short break, or steer conversations toward solution. Okay. Another challenge is, of course, deadlocks and stalemates, right? So why do deadlocks happen? Firstly, rigid positions, right? So parties refuse to compromise, um, or even to disclose what's really going on anyway, right? Emotional barriers, so the anger or resentment can block progress. Lack of trust, they fear being taken advantage of, no matter how much you reassure them. Unrealistic expectations, so demands that the other party cannot reasonably meet. Okay, so what are some strategies to break deadlocks in mediation? So we're going to look at the deadlock cause on one side of the table, and then we're going to look at the possible mediation strategy on the other side. So where you have stubbornness on both sides, right? As a mediator, you want to shift focus from positions. I want X, the interest. Why do you want it? Emotional resistance. As a mediator, you can acknowledge emotions, allow venting, refocus on problem solving. Mistrust, use reality testing questions. For example, how would this agreement benefit both of you in the long term? Another cause of deadlock is narrow thinking. As a mediator, you want to encourage brainstorming when you explore multiple solutions instead of just one. Legal or procedural barriers, right? You want to bring in neutral experts if necessary, such as legal advisors or HR personnel. Reframing the conversation, so when a stalemate occurs, mediators help shift perspectives, right? For example, before reframing, you'll hear, I won't agree to a deal unless I get a full refund. After reframing by the mediator, it sounds like getting value for money is important. Let's explore options that address your concern. Introducing a BATNA, right, which stands for Best Alternative to Negotiate Agreement. So here you ask, what happens if mediation fails? What's your backup plan? If the alternative is worse, for example, a costly legal battle, parties may be more willing to compromise and collaborate. Cultural sensitivity and bias awareness, right? So this is another challenge to overcome. Firstly, recognize cultural differences, right? Cultural misunderstandings can create communication barriers in mediation, right? It's important to be sensitive to them. So avoiding mediator bias, I mentioned this as the outcome. So mediators must recognize and counteract their own biases to remain neutral. This involves self-awareness. So you must reflect on any personal assumptions or cultural biases that you have. You check for assumptions, right? Instead of assuming someone is difficult, consider your cultural norms play a role. Seek clarification. Ask, can you explain what this means for you? Instead of assuming intent. So, for example, in a Western context, a firm handshake signifies confidence, while in some Asian cultures, a softer handshake is respectful. A mediator should not misinterpret this as a weakness. Strategies for cultural sensitivity. So you must learn as a mediator about different cultural norms without stereotyping. Use culturally inclusive language. Avoid phrases that may carry unintended connotations. Or ask open-ended questions to understand each party's perspective. So this is another comparative table looking at various cultural factors, the potential challenges they can pose in a mediation. and the mediation approach. So direct versus indirect communication, right? A potential challenge. Some cultures prefer blunt honesty, while others avoid confrontation. In a mediation, you want to adapt the communication style. You clarify meaning without forcing directness. Hierarchy and authority, right? So in some cultures, disagreeing with authority is seen as respectful. In the mediation approach, encourage safe dialogue where both parties feel empowered to speak. Body language and gestures. So in some cultures, eye contact, gestures, and tone have different meanings. In mediation, you want to observe nonverbal cues rather, clarify meanings when you're unsure. Decision-making styles. So some cultures value consensus, while others expect one person to make the decision. So identify if a group consultation is needed before reaching an agreement. So coming to an end now, we're going to talk about ethics and professional standards in mediation. The role of ethics in mediation, and of course, when to refer cases to other professionals. So mediation is not just about resolving disputes. It's about doing so in a way that upholds fairness, respect, and trust. Ethical standards just serve as a foundation of effective mediation by ensuring, again, impartiality and neutrality. So mediators must remain completely neutral and avoid taking sides. They must disclose any potential conflicts of interest, for example, personal relationships with one of the parties. If a mediator feels they cannot remain impartial, they should withdraw from the case. For example, if a mediator has previously worked as a consultant for one of the parties, they must disclose this information to avoid concerns of bias. Confidentiality, okay? Everything discussed during mediation must remain private and protected. The mediator cannot disclose discussions or agreements with third parties without consent. Of course, the exception to confidentiality is if there's a risk to harm, legal activity, or if there are mandatory reporting as a for example, in child abuse cases. So for example, in a workplace dispute, an employee may reveal personal concerns that should not be shared with management unless explicitly agreed upon. So voluntary participation and self-determination, again, parties must willingly participate in mediation without coercion. Mediators should ensure that agreements are reached freely and not under pressure. If one party is being pressured or manipulated, the mediator must address the imbalance. For example, in a divorce mediation, one spouse may feel pressured to agree to an unfair settlement. The mediator should ensure that all decisions are made voluntarily. When to refer cases to other professionals, so not all disputes are suitable for mediation. The mediator must recognize when a case requires intervention from other professionals, such as legal experts, mental health professionals, or even law enforcement. So for legal issues beyond mediation, if parties lack legal knowledge, they may need legal counsel before agreeing to terms. Mediation cannot override legal rights or court orders. For example, a complex business contract dispute may require legal review before finalizing an agreement. Cases involving domestic violence or abuse, where mediation may not be appropriate if there is a history of physical, emotional, or psychological abuse. Power imbalance in abusive relationships can prevent fair negotiation. For example, in a divorce mediation, if one spouse fears retaliation, it may be safer to go through the court system. Mental health concerns, so if a participant cannot make rational decisions due to mental illness, addiction, or emotional distress, a psychologist or counselor may need to be involved. For example, a party suffering from severe anxiety or trauma may struggle to engage in mediation effectively. Criminal matters, mediation is not a substitute for criminal justice. If a crime has been committed, law enforcement should handle it. For example, a case involving fraud, theft, or sexual assault should be referred to authorities rather than mediator. Okay, and we are now at the end, right? So we've time for questions and final reflections. Um, you can share questions or you can share what you're taking away from the discussion. And of course, anything related beyond this presentation, just to mediation. I'll be happy to answer. I don't see anything in the chat. There's no questions in the chat. Do you guys have any questions for me? Anything you want more information on or clarity? Yes, Norman.
Hi, am I audible?
Yes, you are.
Okay, thank you. Thank you very much for giving us an opportunity to be on this session. This is very informative, considering the new changes in civil cases regarding mandatory mediation, the directive on that. So I just wanted to say that throughout like the whole session, as it was gradually moving, I had like questions. I was listening to you drafting, and then you gradually answered every question as you progressed. So it was pretty exciting to go through that. But I think one of the questions I had was, what would then happen? I do know that you said that in cases of power imbalances, the mediator must ensure fair participation. So I was wondering, to what extent do they do that? Like as far as like the background, like their involvement, like their input in the uh, power imbalance. Let's say, for instance, the other person is not as articulate or as firm as they would be in negotiating what they would like to get from the settlement, then what would like the mediator play in that role? And also the second question would be, with regards to the lack of legal precedent in mediation settlements, how do they actually navigate that? Because I do understand that the decisions are, rather than being rigid decisions, they actually encourage like creative and customized decisions from the parties. So those are the two questions I think I have currently. Yeah, I'm just gonna go through my notes and see if I have anything else.
Okay, good questions. With regard to the first one, I think there's always some measure of imbalance in any conflict. I mean, the fact that they find themselves at your table means that, it's lopsided. Like one party is either winning, other party is losing. So the scales are not balanced. In terms of addressing power imbalances, like I said at the outset, it's always helpful to identify. And again, you watch for verbal, not verbal behavior. You can get parties in separate rooms if you need to and ask them. If you picked up on anything, you can ask them for their clarification of what you perceived from their behavior and what they said so far is correct. Correct. Of course, in the ground rules, you can also set rules. For example, equal speaking time. If one party is not as assertive, you as a mediator need to ask them those questions. So you need to say, so yes, I'm hearing you, but you could give us more detail, or are there any other terms that you would like? Or are these terms suitable, or would you like some variation on these terms? Okay, so those are basically prompting questions that if the party doesn't know what to ask, or if they are in danger of agreeing to something that they don't understand, you as a mediator hopefully understand what both parties are thinking by that point, and then you ask those questions in order to prompt a sort of a party that doesn't have as much negotiating, is not so articulate. So you help them to express themselves. Very much like a child, like a little prompted child, without being condescending, of course, but um, you need to do your best as a mediator, not without putting the answer in your mouth, to kind of nudge them towards what you know could be the answer for them, or could be the resolution that they are seeking. So we don't want one party, for example, if they were opposing all the time, and then this party is less articulate, so they just agree. So you then, as a mediator, jump in and say, are these terms suitable for you? Can you see yourself still keeping to them in 5 years' time? Would you like some variation on these terms just to create some options? And then, of course, that gets the party that's less articulate, gets them thinking, and hopefully pushes them in a direction where they can negotiate a little bit better. In terms of the legal or the precedent, it's kind of the sort of, so legal stuff doesn't actually belong in mediation, um, but out of place. But of course, it's been introduced in our system through the courts, through the judicial system. That's one way to get parties to, or let people know that it's an available option in the system. The thing with mediation is that everyone is unique. So unlike legal precedent where we will go and do a search and we will see what are the likely outcomes for my client in this matter, and then we'll sort of give them, sort of project an outcome. And now we have AI to help us to do all of those predictions. But with the mediation, it's not advisable to, for example, treat every family mediation as the same. To treat every workplace mediation as the same. Remember, we're dealing with different people, personalities. Um, like you're saying, some are articulate, some are not so articulate. So you basically got to approach every mediation um, with fresh ears, eyes. Like I said, you got to be self-aware. You got to reflect on your biases. You got to avoid assumptions about people, about their culture. So before a mediation, that's how you as a mediator would prepare internally, right? So everyone is different. You can keep, I guess you can keep personal notes. Not notes about the mediation itself, but maybe some as a mediator you go afterward and you reflect, right? And perhaps to that extent you can predict how a similar mediation would go. But by and large, you don't approach mediation via what has gone before. You have to treat each one as different because again, they're different people, and remember, they're coming to the solution by themselves. So every solution that people come to is going to be unique to their problem. So you cannot take even that solution and impose it on a similar mediation that you might happen in the future. Every party will come to their own. And the reason it's their own solution is because it's the one that they can facilitate. If it's imposed on them, then they're going to do it because you are saying so, etc. But because the mediator said this is what we were likely to agree on, therefore we agreed on it. That now is you injecting yourself into the situation. You have to let them come to the resolution themselves. And by doing that, it means that it's peculiar to their problem, right? And of course, if the same problem arises with between them in future, then of course they can fill out the agreement and say, this is what we have ideas and this is how we're going to solve our own problem. Because we ourselves came up with the solution in the past. Okay, so you can't use mediation precedents or legal precedents to sort of determine how the mediation is going to go. You have to shed all of that and you have to approach each one as a completely brand new, and your mind must be completely clear of any presuppositions, assumptions, anything that would cloud your judgment as a mediator. Your mind has to be clear. Okay.
Yes, thank you very much. I was actually answered, and I like the fact that you actually even delved like deeper to the questions I asked, which was very clarifying. So yeah, thank you very much.
You're welcome, sweetheart. Okay. Any other questions or clarifications or comments? Maybe you observed or participated in mediation before. You can share those insights with the rest of the people. So I'm guessing it was super clear for everybody. And there's no requirement for clarification. So I'm just gonna take you guys' names so I can send you the slides. Yeah. So if there's no more questions, so yes, Norman?
Oh yeah. Oh, I wanted to ask a question with in regards to like the flexibility or the enforceability of appeals, like appeals under mediation, like something which is difficult to achieve, or are there any disadvantages to appeals in mediation as compared to when the matter is taken to court? Like how, what's the difficulty scale in acquiring an appeal in mediation?
No appeal process. That's the thing. I see, that's the thing. You work as a mediator, as the parties, you work towards a resolution. You don't leave that room until everybody's happy. So there's no need to appeal anything. No one's imposing a decision on you. The one of you is going to be unhappy. Right? And of course, if it's not something that is mediatable and you have to go by the court system, then that's what happens. So I'm not saying in every situation you're going to need a resolution, but the whole point of mediation is that it's your own solution. Okay? And if at any point, even despite the mediator's best interest, one party is under pressure, one party is feeling threatened, one party is feeling coerced, then you're better off ending the mediation rather than having the other party's decision, the other party's agreements forced on the other person. You're better off ending that mediation because both parties are not in agreement with what's on paper. Okay, so there's no appeal. There's no appeal because it's something that both of you have arrived at, and hopefully the mediator has ensured that everybody is clear on the terms, everybody is happy, and of course, again, no one walks away as a loser. So no appeal. Okay.
Okay, noted. Thank you very much for that answer.
Okay, so if nobody has any questions, I think we can go away for Friday. Yeah. Thank you for attending. I know who are the serious ones, by the ones that show up. So there were lot of people who signed up. I think it was about 20 people, but um, you guys are the serious ones. Okay, so either this weekend or early next week, I will send you the slides. And of course, please be on the lookout for our upcoming master classes. They'll probably be done by other speakers under our S.A.U.M.E group. Because I'm not an expert, I'm not an expert, but I don't want to harm the sessions and talking about everything. I'd like to have other speakers as well. Yeah, authorities in the field. Right, so yeah, thank you guys. Please have a good weekend and peace out.